My name is Nkechi Taifa, and I'm serving as Chief People's Counsel for this auspicious proceeding, which is charging the United States government with violations of international human rights. The plaintiff class, which I represent, consists of Black, brown, and indigenous people comprising the following racial and national groups. Number one, people of African descent brought to the United States by 400 years of chattel enslavement or by immigration from former slave territories, often as a result of additional economic oppression brought upon them post-enslavement by defendant U.S. government and co-conspirator former colonial powers following the independence of their lands of their birth. Number two, people of Latinx descent, both natives of territories taken or acquired by the expanding United States, and those who migrated to United States territory, often as a result of further economic oppression brought upon them by the defendant U.S. government and the former colonial powers following their independence. And number three, First Nation peoples, original to the lands now occupied by defendant United States, mostly taken by force and or breach of genuine and fraudulent treaties with indigenous nations and or interlopers. The defendant class consists of the executive, legislative, and judicial branches of all levels of United States government, as well as state, county, and local political subdivisions. Thus, on behalf of the plaintiffs, the Black, brown, and indigenous people residing in the United States, I present the following opening statement. In 1903, upon the launch of his seminal treatise, The Souls of Black Folk, historian W.E.B. Du Bois prophesied that the problem of the 20th century would be the problem of the color line, referring to the pernicious role of race in U.S. society. And now, more than 100 years later, his prognosis is even more ominous, as the evidence from this tribunal will show that conditions facing Black, brown, and indigenous peoples residing in the United States during the 21st century amount to genocide. This charge is not the ranting and raving of wild-eyed militancy, but as you will see from testimony and exhibits during this tribunal, results from a careful and methodical analysis of over 400 years of examination and study. This tribunal is, however, by far not the first such inquiry. It comes on the heels of the January to February 2021 International Commission of Inquiry on Systemic Racist Police Violence Against People of African Descent in the United States. The 1992 International Tribunal of Indigenous Peoples and Oppressed Nations from San Francisco. The 1990 International Tribunal on the Human Rights Violations of Political Prisoners and Prisoners of War in the United States, New York. The 1979 International Jurist Report to the UN Human Rights Commission on visit with human rights petitioners in the United States. This tribunal stands on the shoulders of El-Hajj, Malik El-Shabazz, Malcolm X, whose models were land, self-determination, self-defense, and internationalization. And it is in this very sacred space, this building, formerly known as the Audubon Ballroom, where his DNA still manifests as we gather to continue. As we gather to continue to honor his sacrifice and carry on the tradition of his work. And then last, but most major, this October 2021 tribunal stands on the shoulders of the seminal 1951 Civil Rights Congress petition to the UN, "We Charge Genocide, the Crime of Government Against the Negro People," 20 years later published as We Charge Genocide, the historic petition to the United Nations for relief from a crime of the United States government against the Negro people. So this tribunal today, while not unique, seeks to once again unabatedly and unabashedly charge genocide. But this time, rather than a sole reliance on the international treaty, the Convention to Prevent and Punish the Crime of Genocide, the only vehicle available when the original 1951 petition was brought to the UN, today we also seek jurisdiction based on the implementation of that international treaty as documented within the United States Code. Although this tribunal seeks to use the international definition of genocide as a lens to scrutinize 5 key issue areas: policing, mass incarceration, political prisoners, environmental racism, and public health system inequities, and their impact on Black, Brown, and Indigenous communities, the genocidal impact in other systems such as education and the racial wealth gap, etc., could likewise be so examined. I would be remiss if I did not, unfortunately, acknowledge that the term genocide appears to singularly conjure in most minds images of fiery ovens and atrocious massacres. And as such, there is often a blanket denunciation of the applicability of that term to the United States. This censure, while understandable from the colonizer's standpoint, is myopic from the viewpoint of the colonized. Seldom does the colonizer class dispassionately examine the internationally accepted parameters of the term genocide and then methodically apply that definition to the impact of United States policies and practices on particular racial groups. Or if one were to do so, and this tribunal attempts to do such, we hope that you will agree that the definition of genocide against a substantial segment of the Black, Brown, and Indigenous people in the United States is a reality. The evidence that you will hear and review will specifically and unabashedly address the issue of genocide with both testimony and documentary evidence. In this tribunal, we will present the definition of genocide embraced by the international community and analyze its adoption as ratified by the United States. We will tackle a presumptively fundamental barrier, the issue of intent, and discuss how that hurdle just might be overcome. This tribunal will demonstrate far-reaching and grave implications which in many respects parallel the definition of genocide against substantial segments of Black, Brown, and Indigenous communities within the framework of both international law as well as domestic law. Because the issue is so major, and because of the limited white ethnocentric nature of the educational system in the United States, permit me for a moment to delve a little deeper into this background and history. You will hear in either testimony or documentary evidence that the UN General Assembly in 1948 adopted the International Convention on the Prevention and Punishment of the Crime of Genocide. You will hear that the convention confirmed that genocide, whether committed in a time of peace or in a time of war, is a crime under international law, which the contracting parties undertake to prevent and to punish. Genocide, the convention declares, is the committing of certain acts with, quote, the intent to destroy in whole or in part a national, ethnical, racial, religious group. You will learn that according to the International Convention, the following acts constitute genocide. Number one, killing members of the group. Number two, causing serious bodily or mental harm to members of the group. Number three, inflicting upon the group conditions of life calculated to bring about their destruction in whole or in part. Number 4, imposing measures intended to prevent births within the group. Number 5, forcibly transferring children of the group to another group. You will hear that pursuant to the Genocide Convention, however, genocide is not the only actionable act. Related acts such as conspiracy to commit genocide, directing public incitement to commit genocide, attempt to commit genocide, and complicity in its commission. Furthermore, the international definition concludes by reminding the parties that those who commit genocide or any of the other related acts, quote, shall be punished, regardless of whether they are constitutionally responsible rulers, public officials, or private individuals. Now, the UN General Assembly adopted the Genocide Convention in 1948 without dissent, with the United States being the first nation to sign. Indeed, the U.S. delegation played a pivotal role in drafting the International Convention. However, it took the United States 48 long years, 38 years to give its advice and consent to ratification. And one of the articulated reasons for this unconscionable delay was the fear that Black folk in the United States would use the treaty to their advantage. That fear was not without substance. Why? Because in 1951, 3 years after the passage of the Genocide Convention by the United Nations, W.B. Du Bois, William Patterson, Mary Church Terrell, Paul Robeson, and over 90 others presented the United Nations with that historic petition, chronicling the genocidal sufferings, murder, mental assault, and crimes against humanity inflicted against Black people. So what were the reasons for the delay? The documentary evidence you will review will reveal that it included the anxieties of segregationists, that ratification would subject the United States to punishment under the convention based on this country's treatment of Native and Black people. According to an American Bar Association scholar whose committee chronicled the history of the Genocide Convention's ratification process, the Genocide Convention set a record as the most scrutinized and analyzed non-military treaty ever to be considered by the United States Senate. Indeed, the Senate Foreign Relations Committee held hearings for 13 days. More than 200 witnesses representing divergent views testified. The hearings transcript was more than 2,000 pages long. So nearly 40 years after its adoption by the United Nations, and after scores of other nations had finally ratified it, the U.S. Senate finally gave its consent and advice to ratification, subject to the enactment of what is called implementing legislation under federal law. And you know, implementing legislation was now critical because the Genocide Convention, distinct from later international human rights treaties, such as the International Covenant on Civil and Political Rights and the Convention on Elimination of All Forms of Racial Discrimination, the Genocide Convention incorporated a provision that the contracting parties agree to enact the necessary legislation in their respective jurisdictions prior to depositing the ratification documents with the United Nations. This provision was significant in that it ensured that ratification of the Genocide Convention would not be a symbolic gesture, but would have the full force of laws and the authority to enact penalties. April 4th, 1988, President Ronald Reagan signed the Genocide Convention Implementation Act, ratifying the International Genocide Convention in U.S. law. The only treaty that is self-implementing, okay? It doesn't need it. It already came with the implementation. I think they learned from that experience. So all the other ones after that, they sought to limit its application. But the Genocide Convention, it is there. Of course, they did make a couple of changes to limit, in an attempt to limit its applicability. These changes including adding the term specific instead of intent and substantial instead of part, and defining mental harm as the permanent impairment of mental faculties, particularly referring to the application of narcotic drugs. Thus, the Genocide Convention, as codified in U.S. law, Title 18, U.S. Code, Section 1091, reads as following, quote, whoever, whether in time of peace or in time of war, in a circumstance described in subsection D, and with the specific intent to destroy in whole or in substantial part a national, ethnic, racial, or religious group as such, again, 1, kills members of the group. 2, causes serious bodily injury to members of the group. 3, causes the permanent impairment of the mental faculties of members of the group through drugs, torture, or similar techniques. 4, subjects the group to conditions of life that are intended to cause the physical destruction of the group in whole or in part. Imposing measures to prevent births within the group or transfers by force children of the group to another group shall be punished. So jurors, I found it important to just go over this bit of procedural history as part of this tribunal's opening framing, because it is not the history that's normally taught in schools in general, or even law schools. And in fact, the very fact of United States codification has essentially remained hidden from the general public. Esteemed jurors, much of what you will hear during this tribunal arises from institutional and structural racism, in which public policies, institutional practices, cultural representation, and other norms work in various, often reinforcing ways to perpetuate racial and ethnic group inequity. And as such, the quote specific intent prong as inserted by the United States admittedly could be a fundamental hurdle to use of this treaty as codified by the United States law. Indeed, I will submit it is a difficult hurdle, given the restrictive manner in which U.S. courts have historically construed the intent requirement within a general equal protection analysis. Jurors, as you listen to the testimony during this weekend's tribunal and review the documentary exhibits, ask yourself, are these concerns, are these conscious acts intended to cause destruction? Are they the unconscious effects of structural racism, or do they in fact constitute genocide? During this tribunal, you will learn that the United States inflicts police racism and violence against Black, Brown, and Indigenous communities. You will both hear and review through witness-hearing evidence that the United States systemically executes Black, Brown, and Indigenous communities through the unchecked practices of police brutality, the manufacturing of hyper-criminalization, and the perpetration of slow death conditions. Indeed, racially biased and extrajudicial killings against Black people, whether by lynch mobs or officers of the law, fall within the definitional prongs of the Genocide Convention. You will learn that the United States perpetrates a criminal legal system that results in a mass incarceration unparalleled in the world. You will hear testimony that the United States has refused to acknowledge and subsequently address clear evidence of systemic racial bias while systematically criminalizing poverty to the specific detriment of Black, Brown, and Indigenous communities. You will also learn that the oppression and struggle against oppression in the United States has resulted in a class of political prisoners and prisoners of war peculiar to the historic, ongoing, and now normalized reality of colonialism and genocide in the United States imposed upon Black, Brown, and Indigenous people, which started with the incursion and occupation of the Americas by white settlers from Europe in 1619 and continued structurally and systematically to this present day. I will direct your attention specifically to Appendix A, detailing cases of political prisoners in the United States. You will hear the definition of political prisoners as defined by the then 1990 Special International Tribunal on the violation of human rights of political prisoners and prisoners of war in the United States prisons and jails. You will hear testimony about the COINTELPRO, how the U.S. government's once secret illegal campaign seeking to disrupt and destroy movements in general and those led by Black, brown, and indigenous populations in particular was manifest. You will hear comparisons that U.S. political prisoners who fought against United States apartheid are no different than the late President Nelson Mandela, who headed South Africa's African National Congress and eventually was forced to lead armed struggle against the sustained and the systemic violence, racial violence, abuse, and oppression of South African apartheid. The US CIA played a significant role in Mandela's 1962 capture and put him on their terrorist list. Mandela served nearly 27 years in prison. This tribunal would like you to take special note that many of the political prisoners you will either hear about during this tribunal, as well as those testimonies incorporated in the appendix, have served well over 40 years behind bars. You will hear that they have been subjected to lengthy sentences as a result of their politics, beliefs, and conscious actions against their oppression. And many, after having served their court-ordered time, have been repeatedly denied parole. How they have experienced torture and cruel, inhuman, and degrading treatment and punishment, many serving decades in solitary confinement, suffering from medical conditions and neglect, all causing serious bodily and mental harm, all in contravention to international human rights in general and the Genocide Convention in particular. You will hear that in more recent years, more political prisoners, largely supporters of modern day movements such as climate action, Black Lives Matter, and other movements, are being illegally surveilled and detained by the government under pretext of rooting out extremist groups disproportionately composed of people who publicly challenge the dehumanization and oppression of communities of color. You will learn that the United States intentionally inflicts bodily harm on Black, brown, and indigenous people through environmental racism. Specifically, you will hear witness testimony that the United States knowingly created and negligently ignored the Flint water crisis, failed to produce and enforce environmental regulations in Louisiana's Cancer Alley, and deliberately inflicted conditions of life that will bring about physical destruction in the face of natural disasters. Finally, you will learn that the United States has created a health crisis that aids in the destruction in whole or in part of Black, brown, and indigenous communities, creating conditions of genocide through the promulgation of an environment that results in inequitable health conditions that disproportionately and deliberately impact members of the plaintiff class. Through these conditions, the United States has created a mental health crisis, increased infant and mortality rates, and increased rates of disease and death. You will hear testimony that the United States has created the mental health crisis through historically oppressive systems, facilitated an inaccessible healthcare system, resulting in disproportionate health issues in the Black community, and constructed harmful living spaces that triggers disease, delays in biological developments, and often death, and has done so intentionally. And the United States has imposed measures meant to prevent births to Black, brown, and indigenous peoples held in detention and coerce those facing charges into sterilization. And finally, the U.S. has intentionally and forcibly transferred the children of Black incarcerated parents and brown immigrants as part of policy. Esteemed jurors, in closing, you have before you an awesome responsibility and a courageous task. Just as in 1955, when Mamie Till Mobley, the mother of Emmett Till, demanded an open casket for the world to see the image of her 14-year-old son, Emmett, savagely mutilated and dumped in Mississippi's Tallahatchie River. The duty of this tribunal is to likewise present an open casket for the world to see and hear the testimonies of Black, brown, and indigenous people who have been subjected to human rights abuses. Open it up, Mamie Till demanded. Let the world see what they did to my boy, she demanded, as her son's mangled and battered body was thrust into public view. And indeed, her decision forced the nation and the world to face in shocked disbelief the horror of racism. This tribunal will likewise open up the voluminous body of evidence for the world to see, and hopefully, with your verdict, begin the process to hold those responsible accountable. As Dr. Martin Luther King once stated, the ultimate test of a person is not where she stands in moments of comfort, in moments of convenience, but where she stands in moments of challenge and moments of controversy. Yes, it may be challenging to the United States that we are using not only an international human rights frame to which to present domestic harms, but quite intentionally a genocide frame. It may be controversial for some to hear that mere whispers that crimes against humanity were perpetrated domestically, or that the plaintiffs in this tribunal still charge genocide. But these are not comfortable or convenient times. Just as Mamie Till commanded in 1955, there is a time when we must open up that casket. There is a time when we must right the wrongs. It is once again time for the world to see and to act. The time is now. Moments of crisis also represent moments of opportunity. I humbly ask that this set of international jurors before us today, that you listen to all of the evidence, both testamentary as well as documentary, and return a verdict for justice rooted in international human rights law. Thank you very much.